is look at the scale of the problem that we have in India. We have an overburdened judiciary, and if there is a way that we can make dispute resolution faster, then why shouldn't we go and adopt it? And being a great believer in the use of technology, if it's faster, if it's cost efficient, and it can lead to the same result, which naturally comes with the caveat of there being justice that is done, and ends up in the culmination of a dispute, then of course it should be adopted. Let's put it all in perspective. Online dispute resolution started, we started speaking about it 10 or 15 years ago when we started building on e-commerce. And to a large extent, it's really been about a voluntary submission of parties, consumers, to an online dispute resolution mechanism, because it's an easier way to go to resolve small disputes. Now that's been done at the voluntary stage because it's more convenient to do so. COVID-19 presents a slightly different problem. It's not about convenience, it's about disability. You're in a position today where you cannot go to court, where parties cannot come together, counsel cannot come together, but work must carry on. And in the same way that you've started implementing strategies for work from home, there's this entire concept about now looking at online dispute resolution being done for regular cases which otherwise went to court. Let me just divide the category of cases into two broad spheres. One, there are private disputes, and two, there are public disputes. Okay, public disputes could be environmental disputes, could be any other public causes, writ petitions that are filed. And there are those concerns which arise. And the question is whether you transpose them into an online dispute resolution world. And then when you look at private disputes, yes, at one level, PRAMOD said that there are consumer disputes, and those consumer disputes are small claims that arise between consumer and a large corporate party. But there are also large contractual disputes. You know, the ones that go to big arbitrations, the ones that end up in a court, the ones where you need an injunction. And the question is, can you transpose those into the online world? And the answer is yes, theoretically you can. But you've got to remember a couple of things. Those are adjudications which are rarely dependent on the voluntary act of parties. There is always a hostile party, and that hostile party deserves a right to be heard. And there are two critical aspects which you have to remember. One, in relation to disputes which involve a hostile party, you have to ensure that there is a right of a fair hearing. You know, law students around the world, and everybody's heard about the doctrine audi altrum partem, that has to be complied with, and any online dispute resolution mechanism needs to be able to provide for that. The other aspect that is extremely critical is the public access to justice. We are in the common law world where public access has been granted to the conduct of court proceedings, and I'm happy to elaborate on that a little more if I have to. But any online dispute resolution mechanism which deals with dispute resolution of a public nature or even of a private nature has to allow for the public access to justice, unless and of course, in a private setting like an arbitration, parties have chosen to make it confidential. Now, it is a question of being able to transpose those real concerns into the online world. And if you can do that, then of course you should use technology. Does that require a retailoring of the procedure? Well, to some extent, yes. And again, it's something I'd be happy to elaborate on if we have the time to do it. But until and unless those concerns are met, I think you can't just give online dispute resolution a complete thumbs up. It is a great way to go. It should be the way we should go, but we have to build in safeguards to ensure that real concerns of a disputing litigant are met.
Thank you very much, Nakul. Very interesting to see the public-private divide that you sort of brought out. So what do you suggest then, if we're really looking at a post-COVID world in which there will be change in terms of, I mean, while we may have a lockdown lifted on May 2nd or 3rd, you know, the risk of access to justice, but, you know, we're still concerned about socializing. So this is really the point on which change should actually actively be brought about. So how do you, sort of suggest, do you have any thoughts on how this change can be brought about, both for private as well as public disputes, and particularly keeping in mind, the hostile parties that you spoke about?
So I'll just give you one example. I mean, let's just look at public access to court hearings. There are decisions of the Indian Supreme Court, and they go all the way back to 1966, where the court has taken the view that it is imperative in the common law world to ensure that the public has access to an open court hearing. And it's very interesting. Let me just read out one quotation to you from the decision of the Supreme Court. And where the Supreme Court literally said, and I'm just going to quote from this case in 1966, saying, public trial in open court is undoubtedly essential for the healthy, objective, and fair administration of justice. Trial held subject to public scrutiny and gaze naturally acts as a check against judicial caprice and vagaries, and serves as a powerful instrument for creating confidence of the public in the fairness, objectivity, and impartiality of the administration of justice. Now, what we are seeing today in terms of the virtual hearings that are taking place in court is hearing which is inter partes, which is not open to the public. There are softwares, there are mechanisms where the public can view hearings, and there is no reason why an investment should not be done by the state, by the judiciary, in adopting those systems where, while litigating parties may have their lawyers argue a case, it should be open to the public to see. I'll just give you just following up on this example, a lot of us were looking at the UK Supreme Court hearing the Brexit case. No counsel was disturbed in the presentations that were being made to the court, but the entire world got to see what happened. And that is what we need to imbibe into the online world if you want to proceed with virtual hearings.
Thank you very much, Nakul. There are a couple of points that would be interesting to come back to, but I'll first go to CHAHAT and then come back. But the only comment that I had was, I think online dispute resolution could act as a court of record. I mean, we could preserve actually everything that is said or document it in a fashion that even remarks that are made by counsel could be documented. So everybody would be far more careful on what is being said and what is recorded, whereas otherwise in courts, what actually goes down in orders is the only thing that is preserved. And so sometimes remarks are said by counsel or even passing remarks by judges, which they're not bound to sort of adhere to in the next hearing. But I'll pause there and go to CHAHAT. CHAHAT, just wanted to get your perspective on what the SIAC is doing in this context today. Do you see a new look at arbitration? I just also want you to talk a little bit about your rules and sort of give us an introduction about online dispute resolution from your end. Thank you.
Sure. Thank you, Poornima. It's a pleasure to be here today. Before I speak on online dispute resolution from the perspective of SIAC, I quickly wanted to, for the benefit of the viewers, talk about how SIAC is functioning in the COVID crisis. I'm very happy to inform that SIAC is fully operational, although the staff and the lawyers are telecommuting for the moment. The transition from working from office to working remotely has been pretty smooth because SIIC arbitrations are administered by way of a case management software, which can also be accessed remotely. So this brings me to the topic of today's webinar, which is on online dispute resolution. One of the trends that I am seeing in my cases at SIAC is that for small claims, relatively straightforward disputes, which are not very evidence heavy, parties are able to sort of agree to dispense with an in-person hearing and agree on an online dispute resolution. So at least for those small, straightforward cases, parties are sort of agreeing on online dispute resolution. Even in some large-scale cases, which are pretty complex, we have seen parties agree on online dispute resolution, but I think those depend on which stage of the proceedings those arbitrations are at. Typically, if the arbitration is fairly at an early stage, where the hearing is for, say, a procedural application on joinder, for example, or consolidation, or even if it's for a case management conference, parties are sort of conducting that by way of virtual hearings. However, if it comes to evidentiary hearing, which may require more logistical coordination, where parties may be situated in a lot of jurisdictions, where, for example, some documents may not be accessible at the moment in view of circuit breaker measures or the lockdown or quarantine orders issued by governments across the world, we have seen some resistance from respondents and even claimants. So parties have sort of mutually decided to postpone the hearings in those cases. Also, I wanted to share with the viewers that very recently, SIIC administered 2 emergency arbitrator hearings in these times. In both of these cases, the arbitrator was appointed within 1 day, as is required under SIIC rules. In both of these cases, the hearing was conducted on a virtual platform. And also in these cases, the determination was rendered within a period of 14 days, as is required under the time frame under SIIC rules. Also, for the viewers who may be interested in the field of law and technology, I wanted to sort of recommend one book. I promise that this is not a paid promotion, but there's this book called Online Courts and Future of Justice, and it's by this author called Richard Susskind. And this gentleman was the IT advisor for the Chief Justice of England and Wales for over 2 decades, and is considered an authority on law and information technology. And he sort of, in his book, Online Courts and the Future of Justice, argues as to how courts have major reforms have to be sort of carried out in the court system to improve access to justice. Actually, this brings me to the benefits of arbitration and SIIC arbitration in particular, because arbitrations as compared to court-based dispute resolutions are not subject to rigorous civil procedures, and parties are able to sort of determine their procedure on a case-by-case basis. What I mean, in other words, is that if in a simple, straightforward dispute, parties along with the tribunal decide that this case is fit for online dispute resolution, they can do so. And if they feel this is a larger, complex case which may require in-person hearing, they have that option as well. In terms of a specific SIIC procedure, we have Rule 19, which essentially allows the tribunal to determine a procedure of a particular case after taking in view the parties' comments with the view to achieve a fair, economical, expeditious, and a final and a binding award. So we routinely see documents-only arbitration, for example, under expedited procedure, where tribunals routinely exercise such discretion to reduce costs and also dispose of the arbitration as quickly as they can. So these are my initial remarks on ODR.
Thank you, CHAHAT. I'd be quite keen for you to pick up the thread on the challenges to sort of look at expedited procedures. Even though arbitration is a consensual process and parties would have signed in, do you actually see a situation where people are coming in and saying, look, there are certain challenges to the resolution of ODR. in these times, because there may be a party who doesn't actually want to be part of it and may avoid it opportunistically or otherwise. Could you please sort of talk about that? I'd be keen to also understand how many Indian parties are buying into the expedited procedure to sort of switch to a legal online platform.
Sure. I'll start off with the popularity of expedited procedures under the SIIC framework. I would say that SIIC the expedited procedure are perhaps one of the most sought after procedures that we have. And we have now crossed more than 500 applications that the institution has processed from time to time. In terms of deciding whether or not to allow an expedited procedure application in these times, you would sort of need to understand how these applications are processed under SIIC rules. So typically what we would see is that a claimant would file a notice of arbitration, and along with that make an application for the case to be conducted pursuant to the expedited procedure. Typically, the SIIC case counsel would invite views from the other side, one or more respondents as the case may be, and prepare a case briefing form for the SIIC's president, Gary Bond, to decide whether or not that particular case is to be decided on the basis of expedited procedure. Now, a party can very well make a case that a particular dispute is not well suited for expedited procedure, and the reasons could be various. In light of this webinar, a very genuine reason could be that it's a complex dispute. Some of the documents are not accessible. Other witnesses are located in situations where they do not have internet access, and you don't really know how the situation is evolving. So depending on the facts and circumstances of each case, the president would make a determination of regarding whether or not to sort of allow that application. And hypothetically, even if say the president rejects an application for expedited procedure in a case, if I were a claimant, I could still make a case and request the tribunal to dispose of that matter as soon as possible. Although it would not be, strictly speaking, an expedited procedure pursuant to SIIC rules, but still a claimant could make out a case for deciding the dispute as fast as possible.
Thank you, CHAHAT. Just a housekeeping announcement. Participants are welcome to type in questions in the Q&A section of your screen, and we'll try and pick them up as and when we get the opportunity to do so. I will do a quick second round of questions with the panelists, and when we are happy to take questions from the audience as well. Pramod, coming back to you, wanted to check with you if there was any impediment in terms of actual access to technology. A large bank such as yours will be working with folks from across the spectrum in a varied and complex country such as ours. Has that been an impediment? Has there been a perception that people are asking to use platforms or technology which they are not comfortable with? Or sometimes has that been used as an excuse to delay proceedings? I just wanted to get your thoughts on that perspective. And if you could talk about building trust, which has been a recurring theme in the ODR world, to see how have you sort of sought to build trust, particularly in such an important, trustworthy sort of space such as banking? Thank you.
Thanks. I think there are two ways to look at it. We have customers who I would call are digital natives. They are, first time onboarded in a digital platform itself. So really not a challenge in terms for them to adopt to this mode of dispute resolution. For us, that is one segment, but the other segments are those that are already on our platforms such as the mobile banking and internet banking, and we can see their comfort level from that pattern. So once their behavior is visible on that is when I would say it becomes easier to propose this as well and get people to agree to it. I think it will take a little more time for trust to build up. I think trust becomes visible when they see the outcome. They see that they have had a fairness in both how they could put across their issues and so on. And truly, the platform that we are working with, we keep on encouraging them to looking at examples such as what CHAHAT was describing, what CHAHAT does. Truly, it's not that the platform or the institution will become a challenger to CHAHAT. It is in a very different milieu, very different environment, looking at consumers, as I said. And yet to be able to say that, can they be document only? To me, the question would be to say that at first you have to gain trust, and that might actually be to emphasize the availability of video conference. That might be to actually emphasize the availability of audio conferencing. And of course, transcripting happening, the point you were making about that records are easier to maintain, that people are able to chat and as well as look at those records of what happened in the prior discussion. So I think as long as they see all of it and the outcomes are capable of being tested by them to say, yes, this is why the arbitrator decided this way, should build that up. The other, and this is the ICICI specific, sort of approach that we have taken. What we have said is at no point will we ever ask the customer to waive their rights to whatever other forums they have access to. So they are free to go, indeed, let's say to the consumer forums or civil courts as their choices. We will invoke this process and obviously wait for them to come onto the platform and the institution to deal with them. But will we answer to the courts in the civil courts or the consumer forums? We will. I think it is then for the consumer to make that choice of saying, yes, I think I will also bring my disputes first to this institution platform. See, wait for its resolution, and if that doesn't work, really invoke other rights. I think that would be the key to for us to actually build and gain that trust. At least that's the aspiration, but happy to elaborate if you think it's required.
Thank you, Pramod. There's a question on transparency. I think you would be the best on the panel to address it simply because you've used it in the past in such close quarters. So has there been any concern on transparency, particularly when there's an adversarial setting, and NAKUL will bear this out also in court, remarks are made and arguments are heated. So especially if ICICI is providing that platform, are there issues of concerns about transparency that the counterparty may raise because it's your platform?
No. So I must correct that misimpression. So the platform is indeed independent. We are indeed a committed user of that platform and therefore have signed up to be a user. But we are just an equivalent of a disputing party, which is the counterparty as well. So the platform is very much independent of ICICI. We see that as a crucial step in how the institutional framework evolves for ODR as well. So that I would like to take that away. But on the other hand, transparency, I think, as I said, the ability to see the profile of the arbitrator, to actually be able to know what all submissions have been made, being able to see them real time. And also there is a thing which we have got encouraged with all of our discussions with folks in the ODR world also, which is that explore mediation too, right? So at some level, the kind of expectation I have is that there will be an arbitration, mediation, arbitration, such that it culminates in an award, but really that we are able to have conversation to get to the right outcomes. And I think that is something as a learning which came to us. So I know you practitioners will, it just slips off your tongue to say aab mein daab and so on. But believe me, for an in-house counsel who's only looked at civil courts and DRTs for our enforcement, we really have moved quite a bit in terms of getting that knowledge onboarded for ourselves. So all of those are what I'm hoping will work and demonstrate the transparency. The institution will and should obviously uphold all of the traditions of what an arbitral institute does today. As I said, the aspiration is to look at a CIAC or look at other players and say that that is the kind of expectation you should have, except that you're working in a consumer setting, right? So I think that's the way I would put it.
Thank you, Pramod. NAKUL, there's a question that's come up, and I thought, while you continue to chat about what we were speaking about, do you see a concern in terms of enforceability of arbitral awards that are done online completely? And I will look to Chahat also to comment on this. In the absence of specific regulation in India on that, and we haven't actually, we know judgments have talked about the use of technology in India while, dispute resolution context, but we haven't actually seen much discussion in terms of enforceability of an online arbitral award. What are your thoughts on that?
So you're right, Poornima, when we brought in the statute in 1996, nobody was looking at online arbitrations. But I think the world has evolved, and over the years, a lot of arbitral awards which do come in for enforcement have elements of an online platform which form part of the procedure. A lot of procedural hearings are held over the telephone. A lot of matters which relate to interim orders, especially in international commercial arbitration, could be held over the telephone. And some facets of a trial in one arbitration may involve the cross-examination of witnesses through video conferencing. And I don't think there has been any court decision which has taken the view that just because a part of the procedure was done over the telephone or was done through video conferencing would in any way make the award unenforceable. Which really brings it back to the fundamental issue. Has there been a deprivation of due process because the online platform has been used? And that's what we need to guard for. I mean, I spoke about public access to justice as far as courts are concerned and litigations are concerned. But when you transpose this to an arbitration, what is important is that due process has to be complied with. So when you're looking at, say, cross-examination of witnesses, yes, I mean, it does happen through video conferencing when witnesses are outside of a particular country. It's more convenient and cheaper to do it by way of video conferencing. But you're looking at a slightly different scenario here. If it's a totally online hearing, you're looking at, and let's put it from the COVID-19 situation. You're looking at the team of counsel being separated. You're looking at the witnesses being separated. You're looking at the people who are going to be your decision makers, if there are 3 arbitrators, being separated. Everybody is in a silo of his own. So what happens if in the middle of a cross-examination comes an answer where the cross-examiner needs to take instructions? If you're doing live transcription, there's a sudden pause and you're hurrying and trying to get instructions, which to a large to that extent destroys the manner of cross-examination that is done in a real life scenario, because you get your instructions and literally within 20 seconds you would have your next question. That might take 15 minutes in this scenario. And if that's going to likely lead to a deprivation of due process, yes, there are concerns. So these are aspects that we need to overcome. And if you can successfully overcome them, then yes, I think this is something that's great, and it is the way that we should be going. I mean, this is slightly off the topic, but I mean, I think the true test to the success of online dispute resolution will come in where in large value disputes, people have the option of choosing a physical hearing as opposed to an online hearing, and they would be happy to opt for that online hearing because it has all the safeguards that are there in a physical hearing.
Thank you, Nakul. I think you brought out that due process point very, very well, and it strikes home. So just to follow up then, in terms of truly, if there is a question of Sunil Kakkad from WLG, a senior practitioner based out of the UK, and because you're, in the context of your cross-border conversations that you've had with your experience practicing in the UK, Singapore, and India, do you think post-COVID, it would be business as usual, we'd be back in courts, or would it be something that we've learned in this? And if sufficient safeguards are built, would we be actually looking to more online dispute resolution from the perspective of cost and efficiency, at least, so that corporates would really bite this and see how we would go forward?
Change, there's always resistance to change, and it's very easy to say that, listen, come September, we'll all be back in court. If you're looking at it from an Indian court scenario, you're going to be looking at the overcrowded courts and, these really flamboyant hearings that happen, pulling off interim orders in the way you want to, in the way a lot of counsel are used to pulling them off. That's not a scenario that is practiced or adopted in courts in Singapore or in London, where hearings are slightly more structured. But at some point, change has to be brought about. I mean, change is brought about when circumstances force change. And COVID-19 is a circumstance which is forcing people to change and think differently. Now, when I look at it from an English or a Singapore scenario, I think replicating what transpires at a hearing there into an online hearing is a little more easier. The reason is most court hearings there also get recorded. So counsel are very careful about what they speak, how they present their case, and about the time limits that they have in their presentation. Now that doesn't happen in India. So I think there'll be greater resistance in India as compared to Singapore and London. But I think Indians and Indian courts have now understood that it is imperative that we adopt this technology. They're realizing the benefits of this technology because they're now using this technology in this phase. And I can only hope that, come July or come September, the technology is further improved upon to be able to give people that option.
Thank you, Nakul. Chahat, if you could pick that up, please. Just to sort of your experience, pre-COVID, did you see interest in online disputes? Post-COVID, business as usual, do you think that the SICI, of course, would still be interested in looking at this, particularly from a cross-border dispute resolution perspective? Would it save time and energy and money? Please.
Sure. Sure. So just coming before I come to your question, just touching upon one point that Nakul mentioned about due process and enforcement. Another hypothetical to sort of consider here is what happens where parties sort of have agreed on venue as well as seat in their arbitration clause, and then one of the parties sort of asks for an online dispute resolution, whether the tribunal then is able to sort of unilaterally determine that the hearings may be shifted on an online platform. So that's those are things that would also have to be considered on a case-by-case basis, because the reading of arbitration clause is in particular very crucial and could potentially be a reason for setting aside or lack of enforcement if not followed. Now coming to your question, I would say yes, definitely there has been an increased demand from the parties to sort of switch to an online based dispute resolution, purely because given the present circumstances. Under SICI's case administration, we do not sort of offer or provide sort of venue, either physical or otherwise, those services to the parties. However, we have put up notices on our website, and we have informed our users that Maxwell Chambers has developed a new service called Maxwell Chambers ADR, which is dedicated to hosting complex arbitrations. And I understand that they already have conducted an arbitration where parties were located in different jurisdictions. I think in that case, parties were situated in Australia, Taiwan, Singapore, and the UK. And I think that platform also has the capability of sort of securing 50 users from different locations. So, I mean, for large-scale disputes which require a large legal team, witnesses, and so on. So Maxwell Chambers is providing that services. But as I said, unfortunately, providing a facility, whether a physical facility or an online platform, is not strictly within SICI's domain.
Thank you, Chahat. PRAMOD, if I may come back to you. There are a couple of questions specifically directed to you, and I thought we could take this opportunity also to speak about to see how you could push the agenda for ODR, or is ODR really restricted only to a certain kind of disputes, i.e. financial disputes? Can that experiment really be taken to other corporates outside of the financial world? That's my first question to you. And the second one is, there's a specific question which comes in to say, could customers have options on various ODR platforms, or would it be recommended to have just one? And what are your views on that? Thank you.
Sure, sure. So very quickly, for me, for instance, in the corporate world, I would look at the supply chain, especially if there are intimate both suppliers or distributors that a corporate has. Would you really want to air dirty linen in public? Would you want to take those disputes into the court? Or would you want a system which at least addresses those? And to me, an ODR platform affords that opportunity for the corporate. Consumer disputes is at least where I feel there is a lot of progress we can make, and those consumers need not just be financial sector; they can be across the various spectrum. And that is exactly where I feel our both mass technology and what we reach out to customers with needs to be accompanied with this particular push. If today we are able to offer various services and products online, I think they deserve having dispute resolution online as well. I think that's the way I sort of look at it. So a lot of my effort has been to sort of say that there has to be some sort of equality which comes in the play between consumers and corporates, and at maybe the ODR platform can be that big level. So I don't know if I managed to convey at least how I sort of see it. I can mention one particular inspiration indeed for how we approached it was also what Hindustan Unilever did, HUL. And they adopted a panel of conciliators. So not necessarily falling in arbitration or mediation camp, but conciliators. And what they said to their suppliers was that if we have a dispute, this panel is the one which will sort of address or resolve issues. If the decision is against HUL, we commit not to appealing it.
Right.
On the other hand, you are free to go ahead and appeal as well. And that I felt both brought trust, but also that parity in saying that let's migrate to this process. And which is what I would say. I would say that today COVID-19 is also testing our supply chain and so on, especially those that are linked in the global supply chain. But truly, do you want to upset your supplier? Do you want to upset your distributor when how things are actually organized in the corporate sector? So I would say that makes for a natural fit. Vendors, a key supplier, and then of course, as I said, consumers. Switching gears to your second question, which I can see is posted up here as well, which is that give option about various different platforms. I think, we have benefit of CHAHAT and NAKUL here, but mostly what I would say is that each of the institutional ODR platforms will evolve their own rules, will have their own subsystem in which, for instance, the CAC doesn't offer a facility at all, but a ODR institution will necessarily need to offer that platform, to be able to do things. I think those variations both are welcome, but equally which make it difficult for a corporate to say, I will sign up with 10 platforms. I think we will end up having to choose. The equivalent in the corporate side would be, if I say, oh, you can choose between HKIC, SAIC, and ICC. It doesn't work that way. So you really try and figure and fix one particular institution at least. And I have a feeling that's exactly how it might play out even for corporates also, or banks such as ourselves. But can that evolve? So we have different product segments, we have different product lines. Could it be that I say for one product line it's one institution and for the other it's something else? Possible. Right. I also expect that these are all developing times. I think each of the ODR institutions is recreating based on what they hear. So I'm hoping there will be far more response in international corporate commercial arbitration. Bringing that to the consumers is what I think would be the real challenge.
Thank you, Pramod. I think that's very well articulated. The trust point that you brought out with HUL, very, very interesting. So you go that extra mile so that, there is a buy-in from your stakeholders. Very interesting and useful for dispute practitioners across the board, online or offline dispute resolution. sorry, I just muted myself there. So I just wanted to come to you on your thoughts about enforcement of online dispute resolution awards. Just checking whether you've had any, experience on that, and whether that makes it different from the perspective of the SICI. There are some questions coming in. Arjun, maybe you can take a couple, because while I sort of ask CHAHAT to answer this question. Thank you.
Sure. I think the answer there was covered by NAKUL. I think the key is to ensure that the parties' due process rights are not violated. So I think that's the key there. An experienced tribunal would sort of understand and know how to run a virtual hearing and ensure that parties are given an opportunity to present their cases to the fullest extent. And I think that would be a very, very important factor to consider. And secondly, as I also mentioned, it would also depend and turn on the wording of the arbitration clause. Hypothetically, if parties have agreed on a physical hearing at a dedicated venue, then presumptively, a tribunal may be reluctant to sort of conduct an online hearing in the first place. However, going forward, if parties do realize that for simple, straightforward disputes, they can, within their contracts, sort of indicate language to the extent that any disputes will be referred to SICI under expedited procedure and will be conducted on an online platform, then the tribunal necessarily would conduct the hearing on an online platform, and the parties could then, depending on the facts and situation of that case, decide which online platform is well suited for their case. I mean, there's so many services these days, so the parties would therefore then have the opportunity to make a cost-benefit analysis and sort of decide on which platform to go for.
Thank you. Nakul, I think there's one question which I thought would be of interest to you, when it talks about human intervention and what value do we place on human intervention, as in these discussions on online dispute resolution. How and what kind of discussion can we have in terms of actually what value do we place on human interaction? If you could just talk to us on that in the context, obviously, of dispute resolution.
So Poornima, the way things have gone till now, we place a significant amount of value on human interaction, because everybody wants to do a hearing physically. Everybody wants a trial to proceed physically. A lot of that is for the reason that you're looking at reactions. So if I am a counsel and I'm arguing a case, and I could be arguing an appeal, a public law case in court, I could be doing an arbitration, I am literally looking at the arbitral tribunal or the judges to see how they are reacting to my submissions. If I am doing a cross-examination and I'm trying to make the witness look bad, naturally I want the tribunal or a judge to look at the witness and say, yes, this fellow is lying. And we place a great amount of emphasis on that level of human interaction when we conduct court cases or we do arbitrations. Does that need to change? I think the answer to that is yes. I think we overemphasize this, because a lot of the world that we're looking at today, especially in relation to commercial cases, is really based on documents which judges will read, which they will decipher, and when you're looking at that, the level of the level of human interaction does necessarily reduce. I mean, let's just look at Amazon as an example. They started off as booksellers because people thought that nobody would buy anything other than a book online. Look at where they are today. I mean, we don't go to the supermarket because everything is available on Amazon. And it's not just a tried and tested product that we go and buy. We buy literally things we've never seen in our life before because they're available. So if our mindset has taken 20 years to change and be ready to let Amazon literally be the front runner for us to go to when we want to buy things, I see no reason why our mindset is not going to change with respect to the human interaction that is involved with a court hearing or an arbitral tribunal hearing.
So just wanted to push you a little more there, Nakul. So if you were to sit as an arbitrator, and I know you do, in an online dispute resolution process, either on a platform or with the SIAC, would you have additional challenges, to comply with due process or to maintain records, or just the lack of human interface as we just discussed? Your thoughts on that?
I think the real challenge that I would have is to ensure that if there are two parties who are appearing in an online dispute, would be to make sure that they're both on a level playing field. And when you're looking at international parties, that may not always be the case. You may have one party which may have the most fantastic document management system, and another party which pretty much wouldn't even have a scanner to be able to put the documents in place. That's not a level playing field. So if I'm sitting as an arbitrator, I think one of the necessities to go through a successful dispute resolution mechanism would be to ensure that both parties have exactly the same thing, which might be even as simple as a proper internet connection and the ability of having 2 or 3 video screens to be able to proceed with the hearing.
Thank you. Pramod, if I may come to you, a couple of questions again, some sent to me privately. Just wanted to hear your thoughts on blockchain. I know we didn't really discuss
I just need to, if I could, I read the question as whether without having any human interaction at all, I guess that includes the arbitrators, because I can see a clarification about ODR by machines. So I would just, want to tell the audience, yes, it is possible, but we have to be clear about for what type of dispute. For instance, if it is, I don't know, in a bank's context, a failed payment, right? Yes, we can electronically look at our records, whether that payment failed or not. So if you have raised a dispute, hopefully we should be able to resolve it. In fact, without, somebody having to decide what happened there. A credit card swipe, which you disclaim, we can probably again verify whether that happened, didn't happen, and so on. So wherever there is an electronic footprint, which can be pinged and checked for and reported back on, is possibly where you can have no intervention at all. Would we still want human eyes to look at it? I think the answer would be yes. Only for the reason nobody wants to get gamed. Nobody wants that we have algorithms which give you a refund when you say 1, 2, and 3. If we think people are going to say 1, 2, and 3 because that refund is forthcoming, obviously you will sort of put curbs on it, or at least say let's apply our human mind to looking at those. But how many more can come under that category? I would say, I read a question also about blockchain, so I would put it in the same category as AI, machine learning. They're all there, but they all have still a long way to go before they replace you.
Thank you, Pramod. I just wanted to follow up with one other question. Just wanted to check, have you seen any risks in terms of maintaining digital records with the sheer numbers that, that could add up in a bank such as yours? And with concerns of privacy and sensitive data and discussions around the new PDP bill, what are the concerns there and what are the challenges that you face?
So truly, I think the reality is that we as a bank are already quite, meant to make sure that there is banking secrecy, confidentiality to everything that we do, that our customers do with us. So yes, there is an IT layer which sort of both looks at cybersecurity, looks at safeguarding our data, which is usually kept digitally. And a lot of it is legal obligations without the PDP as well, right? So we have both the Information Technology Act, which imposes restrictions on how we both process data, how we look at sensitive personal data. We also operate internationally, so we end up having the GDPR norms, which are also applicable to some portions of our business. So truly across the spectrum, we are quite sensitive to it. So now when we deal with a platform, when we deal with an institution which is going to host data online, one, arbitration comes with its own obligations of confidentiality. So to us, that is one layer which the institution itself needs to cater to. But before we onboard a platform, we would obviously want to satisfy ourselves on their capability of and safeguarding of the information which will flow to them. So clearly, they will need to match up to, if not exceed, the IT security standards for banks if we are signing up with a platform. So I think that is the expectation which anybody developing such a platform should have, could have. And that in turn gives the confidence to the customers as well that there is data security and safeguarding of confidential information.
Thank you, Pramod. I think there are a few online dispute resolution platform folks listening in, and I think that's a high bar for anyone to comply with, but a very, very serious and required bar. I've been told that we are at 1 hour past, which was the time that we set aside. I will take concluding remarks from all the panelists, and if there are any urgent burning questions, please type them in, and we'll try and get them panel to answer them during the course of their concluding remarks. Nakul, may I come to you with your thoughts before we sign off? Thank you.
Yeah, so my simple concluding remark would be that COVID-19 has given us an opportunity of looking at a different way of resolving large-scale disputes, which could be more efficient and user-friendly. And there's no reason why we shouldn't try and go that way. If Amazon has grown the way it's grown, there's no reason why online dispute resolution should not also grow in the right direction.
Thank you, Nakul. Chahat, and then Pramod.
Yeah, so I joined Nakul in saying that ODR is here to stay, and it would be used increasingly in future disputes. Also, one small point, I mean, another trend that I am seeing in my cases because of COVID is that the parties are sort of requesting the tribunal to sort of keep the proceedings in a bin so that they can initiate without prejudice settlement. So perhaps this could also be a good time for parties to bring their disputes to an end and possibly to negotiate a settlement.
Thank you. Pramod?
I think the future of ODR is quite bright. I think, as you mentioned, we started exploring it a little well before COVID situation was upon us. But to concur with Nakul, we should never waste a good crisis. We should make sure that we are harnessing it and indeed deploying it across the board. To me, I think indeed, whether it is the corporates, other banks, NBFCs, anybody who's got a larger customer presence, a mass customer base, should look at the ODR institutions. And I think, as I said, the aspiration should be and measure them against the international arbitral institutions that exist. That's the kind of expectation one would have, both in terms of rules, procedure, but key, which Nakul also mentioned, the due process, being able to establish that there is transparency and quality among the parties on the platform. So I'll stop there.
Thank you very much. It's been a very engaging and a lively discussion. My thanks to everybody who participated. We look forward to continuing this conversation beyond this webinar. Please feel free to write to any of us or all of us, and we look forward to keeping this conversation going. Thank you very much to my panelists. Pramod, it's been very, very lovely to have you here. Your insights, particularly because of your experience. Thank you very much for sparing the time. Nakul, thank you very much for bringing in that very different perspective. And Chahat, thank you for bringing in the institutional perspective. There are still questions. Please write to us. We'll be happy to answer them and come back to you. Thank you very, very much. Take care and stay safe.
Thanks, Poornima.
Thank you.
And thanks, everybody. Pramod, Chahat, thank you very much.
Thank you.
And thank you to all the attendees. I mean, you've heard us for the last 1 hour.
Thank you.
Spent quite a time.